Civil rights, right? Let's look at some definitions. Like literally, I just picked the first three that were off Google. Dictionary.com says the rights to citizens to political, social freedom, equality. Merriam-Webster, the non-political rights of a citizen. I'm going to get to that one in a sec. And FindLaw.com, civil rights concern the basic right to be free from unequal treatment based on certain protected characteristics, race, gender, disability, in employment, education, housing, and access to public facilities. Now, as someone that studies political science, I don't love these definitions. They're all missing at least one major thing in each one, and I'm going to go over each one individually with you. Um, so the dictionary.com one, the rights of citizens to political and social freedom and equality. This, I mean, that's definitely part of a civil right. I think we can all agree on that. But what about economic freedom and equality, right? When we're talking about civil rights, I think we also think about how unequal the wealth is distributed in this country, and like the fact that certain people don't have the same essentially starting place. And so it's kind of hard to have this social and political equality while having economic inequality. So I think that's one major issue with this definition. The second one, the non-political rights of a citizen. This is my least favorite definition of them all, right? Non-political rights. So what is political? What does political even mean? Well, my definition of political, as you guys know, I like a broad definition, is how power is distributed and used in a group of people or society, right? And so, with that broad definition, and I do think this is the definition that kind of applies to this class and politics in general, is it really can apply to anything, right? Say you're going to, this is a very Connecticut specific reference, but if you're going to Pepe's Pizza, you remember Pepe's Pizza owner was supporting giving his money to Trump. So if you buy a pizza from Pepe's Pizza, you are in effect, using your they're using your funds, and so your decision to go buy a slice of pizza from there or go somewhere else is a political act, because it has to do with where the money and where this power is being distributed. When you look at it at that lens, almost everything is political. And so when Merriam-Webster says the non-political rights of a citizen, that doesn't really leave me with much. So, but like, what about the right to vote? What about the right to protest and petition? Are those things civil rights? Because I, I think most of us, when we think about civil rights, like that is definitely included in it. So I'm not sure about this definition. I think it's pretty off in general. And lastly, the third definition, findlaw.com. This one is, we're getting there. We're getting there. Civil rights concern the basic right to be free from unequal treatment based on certain protected characteristics, race, gender, disability, etc., in settings such as employment, education, housing, and access to public facilities. But again, it's missing these kind of political rights. What about economic equality or equity? And is this kind of stuff only limited to employment, education, and housing? I mean, I would argue it applies to literally almost everything, right? So again, a bit of a limited definition, but I think this one kind of gets to the point that it's concerning discrimination, right? That's kind of one of the main things about civil rights. Now, that leads us to the difference between civil rights and civil liberties. And there's a lot of overlap here, obviously. But I think there is an important distinction in the courts, which is kind of this whole kind of tie into everything we're talking about, make an important distinguish between these two. So it's important to kind of go over, right? Civil liberties. Now, I found these two definitions, everything kind of seemed to be based off these two definitions. So let's go through these. One is basic rights and freedoms that are guaranteed, either explicitly identified in the Bill of Rights of the Constitution or interpreted through years by the courts and lawmakers. This is the personal freedoms argument, right? You have certain rights, and I know this is getting confusing because we have things called civil rights, but we have certain rights and freedoms, right, that are explicitly in the Constitution, and you have these no matter what, right? And then the second definition is civil liberties are protections against government actions. I think I prefer this definition, but we'll get into why I think so in a little bit. And just for example, right, Bill of Rights guarantees the citizens to practice whatever religion they want. Government cannot interfere in an individual's freedom of worship, right? So this is a civil liberty. It's freedom from the government getting involved in your religious practice, right? Pretty straightforward stuff. Of course, it gets complicated when you look at some of the things that we call civil liberties, right? Fine law kind of contradicts own definition, if you ask me, right? Well, as we learned in this class, I don't think they're really thinking too hard about it, right? So, right to free speech, I think we could all say that's a civil liberty. Right to privacy, you don't want your government kind of getting involved in yourself, but obviously that's not really true anymore. Right to remain silent, unreasonable searches, we know that one's kind of a farce as well, but it's technically in there. The right to a fair court trial, arguably so, right? But starting to get to the bottom, the right to marry and the right to vote. You already talked about the right to vote, right? I don't think this could be in any way considered a civil liberty because it's not explicitly stated in the Constitution or Bill of Rights, like we talk about. Vote is maybe not as sacred as we think in this country. And then the big one that I've been kind of talking about this entire semester, and we're finally here, the right to marry, right? There's nothing really in the Constitution that says people are allowed to get married, right? It's just not in there. It's kind of assumed thing. And so, maybe, and we'll talk about why the court implies it with their decision on Oberfell versus Hodges. Definition 2, civil liberties or protections against government actions. Again, these first couple ones, free speech, privacy, they're all specifically in the Constitution, and they're all freedoms from the government getting involved in your stuff, except for maybe a fair court trial that's kind of a service, right? But then the right to marry, again, is, how do I put this? Is the government providing the service to get married, or is marriage something that is being denied to certain people before Oberfell versus Hodge rules that everyone has the right to get married, right? And then also the right to vote. We talk about that there are many restrictions on voting. Obviously, one of the big things we talk about is the fact that if you're in prison, you can't vote. And so that's the government kind of doing a harm to you rather than protecting you from itself. So I think there is a lot of gray area here. And I think it's pretty clear. And we're going to go we already talked about the right to vote, early in the semester. So we're going to talk about the right to marry because I think this is a big one. It's still coming up every day. And I think it's one of the more important civil rights questions that we have to tackle in our generation, right? So FindLaw.com actually has a pretty interesting example. The right to marry is a civil liberty, and then by civil liberty they mean in this case like it's something that everyone is entitled to, while gay marriage is a civil rights matter because it's a discrimination issue, right? Which is an interesting distinction. And let's see what the court says essentially. So the court implies that the right to marry is a civil liberty based on life, liberty, property without due process. No person shall be deprived of life, liberty, or property without due process of law, right? And the court is pretty much taking a broad interpretation of, and I think this is the correct interpretation of this, life, liberty, property, in this case, liberty, that marriage, your ability to get married to whoever you want is, under that liberty aspect. And so to deprive that right is unconstitutional. That's essentially what the court said during Oberfell versus Hodges. It's constantly coming up that it might be overruled, especially with more conservative justices. I don't know why I want to say subjects, but this is their reasoning behind it, and I think it's a pretty compelling argument. But let's look a little closer. The right to marry, is it a civil right or is it liberty? Well, let's look at definition 1 for liberty. Is it a guaranteed right or personal freedom? The court is obviously split on this. It wasn't a unanimous decision. So the court argued that marriage is a guaranteed right based on that due process clause, and personal freedom implies the government's obligated, right? It has to recognize that marriage has to recognize everyone's marriages, right? So restricting gay marriage would both be civil rights, right? You're being discriminated, and a civil liberty violation because you're denying some of these basic rights that are enumerated in the Constitution, which I think is, I think that's kind of the right reasoning. That's just my opinion. The dissent, and if you notice, I talked about Clarence Thomas quite a bit, argues that marriage is not an essential liberty, right? He says, which I think is pretty interesting, there's no liberty to get married. You can already have intimate relations and live with whoever you want. He's pretty much saying that the government doesn't have to recognize anything. Like, if you want to live together, that's fine, but the government doesn't have to recognize your marriage. But this is an issue because it becomes discrimination because obviously married people get certain benefits that single people don't. So Clarence Thomas, I know, I think he's on the wrong track for this. But let's look at the second part of a civil liberty, definition two. Is it protection from a government action? So this comes more into the, state by state basis. The Supreme Court ruled that the individual states are infringing on citizens' freedom to marry. Obviously, I think that kind of covered in that first part that we talked about. But the dissent from the conservative side of the court kind of goes against that. Obviously, it's dissent. Liberty has long been understood as individual freedom from government action, not as a right to a particular government entitlement. So again, Thomas is pretty much talking about that. He doesn't feel that the government has to recognize anyone's marriages, and these entitlements that he's talking about, these tax breaks, are the only people that can get them are the people that have been established in current law, right? Which again, this is a discrimination issue. And if you do believe that marriage is part of liberty and that life, liberty, pursuit of happiness for all, then you would disagree with Thomas in this particular point. But Clarence Thomas and the late Justice Scalia firmly disagree with the court's decision on this particular case. And I think it's an incredibly interesting case because it really has to do with reading the Constitution, and the wording is obviously very broad. And how do we interpret this wording? We're going to see what happens in the next couple of years with these more conservative justices. I don't know where it's going to go, but I think this is definitely one that we had to tackle. You know what I mean? It's so relevant to today. Really quick, I did want to give some background to civil rights cases in the United States of America. The one that you have to know, right? That you should know anyway. I'm not really going to test you too strongly on any of this kind of stuff in our quick meeting. I don't expect you to remember every little detail, but Scott versus Sanford is an important case. If you don't know about it, I'll just give you the quick background. Dred Scott was a slave. He moved to Illinois as a free state. They emancipated him, and then he moved back to Missouri, which was a slave state, where he sued for his freedom from his former enslavers, right? This seems kind of cut and dry if you would kind of tackle it in today's world, right? He moved to a free state, he became a free man, and then moving back would not convert him back to a slave, right? The court, as you guys know, I disagree with. For every good decision that the court makes, there's at least two wrong ones. That's what I found, right? So, the majority finds that, African Americans were never intended to be citizens of the United States, right? Despite there being, examples otherwise at the drafting of the Constitution. And then so Dred Scott had no standing in court. Now, no standing in court means that the court should not even look at the case, right? They're just going to drop it. But that's not what they did. The court, obviously, maybe not the most, how do I put it, people friendly to emancipation, were actually completely wrong in this ruling and take an extra step. Not only they don't dismiss the case, but they rule in favor of Sanford and declare the entire Missouri Compromise, which is an equal balance of slave states and free states, an overreach of congressional power. And yes, so what grounds does the court make this ruling? It's on this kind of life, liberty, and happiness clause. Just so you know, you can see the Missouri Compromise here. Equal balance of slave states and free states with some kind of new territory that they're exploring. And this all comes down to due process clause. No person shall be deprived of life, liberty, or property without due process of the law. Essentially, by saying that Sanford does not have standing as a citizen of the United States, that none of this really matters, right? Which is, of course, the incredibly wrong decision, and it's often cited as one of the worst Supreme Court decisions ever. You know what I mean? But I think it's important to kind of really get started right at the beginning. Let me just check anything else that I want to check in here. Yes, this is just for your background information. The Scott versus Sanford obviously has massive ramifications, because if he's pretty much saying that you can't be a free person in a free state and then travel, then this has implications all across the country. And this kind of directly leads into the Republican Party becoming even more popular as the party of kind of emancipation and abolition, and eventually nominates Lincoln for president. And this obviously is the, kind of big push towards the Civil War. So, we've talked about the Supreme Court, we talked about their power. We can see here a court case that has absolutely the wrong ruling that actually leads to massive, massive, massive consequences, and it's quite unfortunate. But I just wanted to give you that quick background on this, and the background on the Oberfell Hodges case, because I've been talking about it forever. I'm going to leave this slide here, leave this lecture here. There's some more slides that if you want to go into a little more detail about the Civil War, but I'm going to move on into